All right, Catherine, it's 10:02. Let's get started. So I'm attorney Joe Pippen. Attorney Catherine Hult is with our firm. She does mainly family law. So we're doing a seminar today on family law. Catherine has put together 10 things, which really turned out to be 20 things, right, Catherine?
That's right.
20 things you need to know in the family law area. So, and you all get a special report with these 20 items that she's come up with. We're going to talk about a few more items as well, and we'll send you, she's got this neat report where she has a topic and then she has a link where you can check out the exact statute on the matter. So, Catherine, why don't we get started? Let me ask a question that's not part of the 20 though.
Great.
Why don't you briefly discuss spousal rights with our audience today? What are the spousal rights in Florida absent a pre or post-marital agreement?
Okay, well, when it comes to divorce, okay, let's look at that first. We are in an equitable distribution state. So spousal rights, when you go through a divorce, the court's going to look at the assets and the liabilities that you have acquired, and you will have the right to an equal distribution of those assets. Also, there could be rights to alimony depending on the particular situation. Let's look at a situation where wife owns a home, she's single, she gets married, and she moves the husband into the house, but does not add his name to the title. What happens if the wife predeceases the husband? Now remember, in this situation, the husband's name is not on title. The answer is, okay, so they've gotten married, wife's name is on the title, husband's name is not, wife dies. The husband has a life estate in the wife's homestead, or he has the right to sell the homestead and get 50% of those net proceeds. So you need to be very careful when you get married, how your assets are titled and whether you have a homestead or not. Florida is very particular when it comes to homestead rights, different from Illinois or other states. So understanding how Florida law governs your spousal rights, your homestead rights is very important, because Florida statutes will put into place certain distributions or the establishment of assets, whether you like them or not. So how do you go about changing Florida law if you're going to get married and to predetermine where you decide where your assets are going to go, either upon divorce or death? Then you have a prenuptial agreement. If you're in a situation where you say, uh-oh, Catherine, I did not get a prenuptial agreement, but now I'm married, am I just lost? And the answer is no. You can do a post-nuptial agreement. Prenuptial agreement, post-nuptial, they're basically the same agreement, except for the post-nuptial agreement is prepared and signed after you're married. So very important to talk to your family law attorney in collaboration with your estate planning attorney to find out what your rights are when you're married.
Yeah, and if you're a little bit worried about your assets after hearing that, and you do not have a pre or post-marital agreement, it's really, if you both can agree, which it could be beneficial to both parties, because you can sign an agreement basically that waives your rights against each other's states. So if you both promised one another, well, I wouldn't do anything, I want you to have, this is, a second marriage or more, and I want your children to have all of your assets, and I know you want my children to have all of my assets, and I promise you I won't do anything active against your estate to try to get what you have. I want you to give what you have to your children, and I want to give what I have to my children, and that's the verbal agreement. Well, verbal agreements don't really work. And my experience is that if one of you died and the one that's left has a very active power of attorney person taking care of him or her, that person can exercise the spousal rights as well. So you're not dealing with promises you made with each other. Sometimes you're dealing with promises of the power of attorney, who's now actively trying to get as much as they can from mom or dad's estate. So,
and the other thing is, when I draft my pre and post nuptial agreements, it's very important that the parties understand that these agreements promote marital harmony. And it's a win-win situation for both parties, especially when it's a second or third marriage. So many of my prenups that I've done, these folks are 60, 70, 80, 90 years old. They're getting married for the second or third time. The very first marriage ended by death or by dissolution of marriage. And these people have pre-existing assets. They've acquired their net worth. They have children. The children are extremely concerned when mom, who's 81 years old and perhaps now has been unmarried or hasn't been married for 10 years. And now she meets a new fella and she's going to get married. And the kids say, wait a minute. What's going to happen to my inheritance? So the way that you can preserve the rights for your children and for your grandchildren and promote that marital harmony is to have a pre or post nuptial agreement.
All right, so Catherine, let me do one of your 20 questions. And again, Catherine,
Okay.
we're giving everyone a special report, and you'll have a link to the website or the statute that explains this in more detail. But one of your questions is, can a husband or wife be liable for each other's torts? They get sued, have an injury, cause damage. Can a spouse be responsible for that when the other spouse is the one at fault that was involved in now, which is litigation?
You know, I found this statute to be very interesting because it used to be on the books where the husband would be responsible for the wife's civil wrongs, or the wife would be responsible for the husband's civil wrongs or negligence. But now that obligation, one spouse to the other, has been abrogated, meaning, and that was in 1951. So after 1951, the Florida statutes say one spouse is not going to be civilly liable for the other spouse's torts. Now, what do torts mean? We're talking about unreasonable actions by one party or another, causing harm to another, there being damages. So just by virtue of being married to your spouse, you are not going to be liable for their civil wrongs. Now, what I want to make very clear is this has nothing to do with whether you have joint debts or, joint consumer debts, joint car loans, jointly established liabilities. So nothing about debts, nothing about joint credit cards, just whether one spouse is civilly liable for the torts of the other spouse simply because they're married. And the answer is no, since 1951.
All right, so what about a child that has causes damage and they're under the age of 18 and they live at home?
Absolutely. This is so important. So when I was putting together my special report and we found out about spouses and the fact there's no civil liability, what about minor children? That means under the age of 18, important, who live at home, not children who have left the house or living with somebody else or in foster care or there's a guardianship, but these kids are living at your home and they maliciously or willfully cause damage to property. You parents can be and more than likely will be found civilly liable for your children's actions. So you can't just say, well, kids are going to do whatever they're going to do. I'm not going to be responsible for it. Parents, wherever this damage has occurred, they can come and file a lawsuit against you, parent, being responsible for your children's actions, and you may get a money judgment against you. So,
Catherine, here's a question for you that's not on your special report, but I think it's interesting for some of our listeners anyway. What is the requirement to follow divorce in Florida? How long do you have to be a resident of Florida before you can follow divorce?
Absolutely. In order to get a divorce here in the state of Florida, there's 3 things that need to be in place. Number 1, it seems kind of obvious, but you need to be married to the person. not just a commitment ceremony and holding hands and I love you and I'm committing myself to you forever without there being the formality of a marriage. So you have to have a marriage, number one. Number two.
By the way, before you go to that, there's one of our points on your special report is there common law marriage in Florida? So I'm going to check that one off and just let you comment briefly about that before you move on to the other requirements.
Okay, so no, there's no common law marriage here in the state of Florida. As of January 1st, 1968, no common law marriage. But listen, that means prior to January 1, 1968, there was common law marriage, but no more. All right, so
I had a quick chat room question that just popped up. They wanted to know would you have to have been married in Florida to get divorced in Florida, was the chat room question.
Great question. You could be married anywhere, China, Russia, Africa, Australia, as long as it was a valid and legitimate marriage in that locale. You can get a divorce in the state of Florida if, okay, so number one, that you're married. Number two, there's an irretrievable breakdown of the marriage. And this is also one of my bullet points. Florida is a no-fault state. 99% of the divorce cases that I file, there's one line in the petition for dissolution of marriage which says the marriage is irretrievably broken, period. Right? Marriage irretrievably broken. The third element that must be present is one of the parties, husband or wife, needs to be a resident of the state of Florida for at least 6 months prior to filing the petition. Now, that's 6 full months, and you need to be able to prove to the court that you've been a resident for 6 months. So how do you do that? Most common is you show your driver's license. And I tell my clients whenever we're filing for divorce, I say, I look at their driver's license. If it was issued more than 6 months prior to, I tell them, do not get a new driver's license because we're going to have to show that driver's license to the court. Are there other ways to prove the 6 months? Yes. If you don't have your driver's license issued more than 6 months prior to the date of filing, you can show your voter's registration card because that shows when you became a resident of the state of Florida, or it states when that card was issued. You also can bring live testimony. You can bring live people into court to say, I know Mary here has been a resident of the state of Florida for at least 6 months prior to filing. So let me tell you, if somebody calls me and they say, Miss Catherine, I was living up in Georgia with my husband and my kids, but we moved down here to the state of Florida. I want to file for divorce. I say, how long have you lived here in the state of Florida? And if the answer is less than 6 months, if they say, Miss Catherine, we've been here for 4 months, I say, hi, come back in 2 months. And we're going to have to get that jurisdiction established. Because if you have not been a resident of the state of Florida for at least 6 months, and you go all the way through the divorce, and there's a final judgment of dissolution of marriage that is entered, it is null and void because there must be those 3 elements in order to establish subject matter jurisdiction. And I tell my clients, subject matter jurisdiction is a big deal. And if we don't have SMJ, you can't get a divorce. And if we go all the way through, it'll be set aside as being null and void.
Catherine, explain if you meet the 6 month requirements and the other requirements, but your spouse lives in another state. Explain that.
That's absolutely fine. Now you run into problems with, okay, subject matter jurisdiction. We understand that. There's also another jurisdiction called personal jurisdiction. Then I start to inquire, have you and your spouse ever resided in the state of Florida together? Does the other spouse have any ties to the state of Florida? And ever so often I get a case where somebody moves to Florida, the other spouse is up north, they've never lived in Florida together, they weren't married in Florida, they don't own any real estate or any property here in the state of Florida. And here's what I tell them. I can get you a divorce. Let's say that there's no kids. I can get you a divorce, and that's it, because there's no personal jurisdiction unless, okay, the other spouse can waive the rights regarding personal jurisdiction, and they can submit themselves to the Florida court. So it all depends on how resistant the other side is. If the other side wants a divorce, then they'll say, yes, I submit to the jurisdiction. Let's just proceed in the state of Florida. If they're being obstinate or obnoxious or don't want the divorce, I could say, no, I'm not going to submit to the jurisdiction. And then my answer is, okay, fine. You don't have to admit to the personal jurisdiction, but this court down here has subject matter jurisdiction, and we're going to get our divorce.
All right, let me go to, we've got like 12 questions in the chat room already, so let me go through some of these pretty quickly. Can you get married by a notary in Florida?
Yes, you can. And I'm going to ask Joe Pippen, you've married people, haven't you?
Yeah, I've done 3 marriage ceremonies so far. It's not something I volunteer to do, but I have, you know, a person can actually get married and you're a notary in your office or in the office if they wanted to, in the conference room. One of my marriages was in a church. One was one of my neighbors in their home at Christmas, and one was on the beach, actually. I've done three marriage ceremonies as a notary, not as an attorney.
So I've done 2, and the last one, it's been a couple years ago, but I finished up the divorce case, and my client had a significant other, wanted to get married relatively quickly after the divorce, and he said, Miss Catherine, can you marry us? And I thought, well, yes. And and then he said, no, then I asked him, well, I'm assuming that you've written up your own vows and stuff. He said, no, we want you to write the vows. And they wanted to get married like a week or so later. So then I'm like scrambling on the internet, trying to figure out how me as notary can do this very respectful, lovely marriage ceremony for these nice folks who did not write their own vows. And I did. Everything was fine. But like Joe said, it's not something that we do on a regular basis.
All right. Can you marry your first cousin in Florida?
Oh, I love this question. We have to walk through this. Number one, okay, let's be real clear. In the state of Florida, you cannot marry your brother or your sister. People are like, whew, thank you. You cannot marry your aunt or your uncle. You cannot marry one of your parents. You can't marry one of your nieces or one of your nephews. Now, here's one thing I want everybody to think about right now. Think about one of your first cousins right now. Think about it. If you have a first cousin, think about him or her. My first question would be, would you want to marry your first cousin? Well, here in the state of Florida, the answer is yes. You can marry your first cousin. And I have had a couple divorces where my client comes in, sitting across the table from me, and has said, Catherine, my husband is my cousin. And I say to them, yes, you can marry your cousin in the state of Florida. And then we proceed with the divorce. So think about this, though. Their mother-in-law, right, is their aunt. That kind of makes it all, Christmas and holidays, it's all very odd and awkward, but the long
or
answer.
Or you could say it'd be more fun. Who knows? It's your attitude about it.
So yes, the answer is in the state of Florida, you can marry your first cousin.
What's the legal age? And again, Catherine has a special report with statutes for you to follow on this if you want to, where you can just link onto the statute. What's the legal age of emancipation in Florida for a child?
18 years old. Now, there's other ways to emancipate. You can get married. You can join the military. Okay, you can emancipate that way. And here's the thing, even if you, or you can file a petition to emancipate and have the court order the emancipation, but you have to be at least 16 years old. But even if you've emancipated by marriage, joining the military, or court order, you still cannot buy alcohol or drink alcohol. That's still 21 here in the state of Florida. And maybe a little tail off of that, Joe, is for purposes of child support. Remember, I'm a marital and family law attorney. Does child support automatically end at the age of 18? And that's one of our questions. Let's say you have a child who turns 18 in January or February, but they're still in high school. You can request through your court documents that that child support continue until that child graduates from high school, as long as the child is 19, or, you can't continue on and on and on as long as the child is not a dependent child, like they have Down syndrome or they have some other developmental disabilities, where then you can ask for child support to continue all the way through to adulthood, all the way through.
One of the more fun questions on your list with a statute that supports your answer, of course, is can you be awarded custody of pets during a divorce proceeding?
That's a huge question. So the answer, the long and short of that is, can you be awarded custody of your pets? The answer is no. Can you be awarded visitation or time sharing with your pets? The answer is no. So what do you do when you have pets and you go through a divorce case? Well, pets, and it's very clear under the Florida case law, and the big case was Bennett versus Bennett. And in that case, the District Court of Appeals stated that your pets, although we love them, very integral parts of who we are and what we do, those pets are considered personal property subject to equitable distribution. So where do we run into a problem? We run into a problem when we have an odd number of pets, 1, 3, or 5. Okay, if we have 2 dogs, okay, we can say, well, 1 dog here, 1 dog here. Or if you have 6 cats, 3 cats here, 3 cats here. When you have 1 dog or a dog, a cat, and a bird, those odd numbers, that the court has to divide those pets like their assets. And there's no other way around it.
All right, so we're going to do another 6 minutes of your points, and then we've got 15 questions already in the chat room.
Wow.
So I'd like to kind of maybe quickly answer those if we can, to get through as many of those as we can. But one of the other interesting questions is, can you take back your maiden name in the divorce? And can a spouse force you to take back your maiden name? Two questions in one there.
All right. So when you're going through a divorce and you've taken the husband's name, many ladies out there say, I want to be restored to my maiden name. And can you do that in the divorce proceeding? And the answer is yes. Does it cost any more? No. It's just one extra line in that final judgment where the wife is restored to her maiden name. However, at that final hearing, I have to ask a couple questions, such as, are you asking to be restored to your maiden name to avoid any criminal prosecution? Okay, because if you're trying to avoid the law, you can't do it. Are you asking to be restored to your maiden name in order to avoid creditors? And if you are, then you can't get a name change. Or if you're asking to go back to your maiden name for any other illegal or immoral purpose. If you're only looking to take back your maiden name, the court will allow that. Now, parents, moms, it depends on how old your kids are. You might decide, I really don't want to be restored to my maiden name because I want my last name to be the same as my children's for purposes of school and taking them to the doctor. Otherwise, I have all these different names going and I like the consistency. Now, the second part of that Joe said, and I think these questions, I put them together because a lot is just based on my experience. When I've represented husbands and they say to me, I don't want her to have my last name anymore. Can we order the wife to take back her maiden name? Can we force her to go back to the maiden name? Now, some of you fellas out there are thinking, well, yeah, I can understand that. And the answer is, what do you think? No, 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 no. You cannot force the wife to take back her maiden name.
All right, so maybe one more fairly quick question here. Can a child testify in a divorce proceeding? I guess mainly if a child's going to testify about custody and where the child wants to be.
That's, once again, that is a big question. And my clients say, my son or my daughter, they want to talk directly to the judge. Well, every case is different. And those of us who have children, we know and understand that children have different maturity levels. You could have a 10-year-old that's very mature, or you could have a 15-year-old that acts like a 7-year-old. Okay, so every case is different. But broad brushing this, the courts, the judges do not like to pull the children into the family law litigation. The judges, for the most part, believe that litigation is for the parents. The kids are to stay out, and they don't want to talk to the children. However, I have had some more rare situations when a motion is filed with the court to allow the judge to talk to the child, what's called in camera. And that means talking to the child in the judge's chambers. And there can be different parameters on that, like the family law attorneys, the divorce attorneys don't get to be in the room to hear what the judge has to say. And the last in-camera hearing that I had with regard to a child, and this was in Hillsborough County, they had the guardian ad litem present, that's the voice of the child, and they also had the emotional support dog. Or I'm not sure it was, I'm not sure what they called it, a therapy dog, but in Hillsborough County, they have a dog that has been specially trained. It's a very expensive dog, constantly gets updated with the training, where they have the dog come in to be with children who are going to testify in criminal cases where there's been sexual abuse. The courts, and there have been studies that when the child can sit there and pet the dog, that they are more comfortable and willing to talk about what's happened in that kind of environment when they're petting the dog. So in my case, we asked for the dog to come into the courtroom, and the child was able to pet the dog and then talk directly to the judge. But right now with COVID, the way that we're doing our court hearings is exactly, my friends, the way it's happening, what you're seeing right now. We do our court hearings by Zoom. So you'll have the judge, you'll have the lawyers, you'll have the parties, you have the guardian ad litem, you'll have the bailiff, you have the court reporter, you have all these boxes. And just think about how difficult that is also when you're trying to submit evidence, okay? Then you're sharing screens, et cetera, et cetera. So whether the court would be more or less willing to talk to children during the COVID and Zoom, it remains to be seen.
All right, well, let me do this. So Catherine has prepared a special report for all of you that would like to have one. There are some many other points in here, and she's got a statute you can link on. I'm just going to mention some of those because I would like to go to the chat room. We have 15 questions. So we'll try to give a 2-minute or less answer to those and see how many of those we can do for the next half an hour. Okay. So in Catherine's report, it talks about custody and visitation, best interest in the child statute for you to look at. The child support guidelines are in her special report. Can a parent waive child support? That's an interesting answer. I mean, if we have finished the 15 questions, we'll come back to that one. And how far back can you go collect back child support payments? There's also, Catherine can talk about that maybe if we can get guys. Want to give the audience the courtesy of trying to answer their questions. Thomas has had his hand raised, so we're going to take one live question, then go to the chat room. Thomas, can you be brief and summarize your question for us? You need to unmute your,
yes.
There you go.
Hi, and I did write in the chat, so we can ignore that. Okay, been married, divorced twice, last marriage really bad. If I got married again, how do I don't want to incur her debt, I don't want to take on her responsibilities. I don't want her to have access to my retirement stuff. I know it sounds terrible, but I'm getting old. I'm 51. I can't do that anymore. So how do I protect me and say, look, what's yours is yours, what's mine's mine. We can build a life together, but I don't want to take on any of her medical debts and get wiped out or anything like that. And I don't want her taking what I've built. Sorry, it sounds harsh, but
No, Thomas, I hear this. You need to have a prenuptial agreement, and that will promote marital harmony, because one of the parts of the prenuptial agreement is full financial disclosure to start off the marriage. All right. So you will know exactly what she owns. She will know what you own, and you're going to know the debt, the finances, whether it's credit card debt, student loan debt, medical debt. All that's going to be disclosed in the prenuptial agreement. Because how many people, when they get married, I mean, how many times you say, well, how much credit card debt do you have? How much student loan debt? What's your car loan? But in this prenup, all that is laid out, and it basically states his is his and hers is hers. And when you get married, you're very careful about, if you purchase any property that has a title and you put it in joint names, then it becomes joint. But if you're a good steward of your property and keep your assets separate and your liabilities separate, then you're going to be fine. But without that prenup, it can be very dangerous. And look, Thomas is 51. He has his assets. When he finds his new lady friend, he wants this to be the last one, right? We don't want to get married and have to get divorced. And so we're going to have a prenup, and it will promote marital harmony for Thomas and his lady friend.
And you'll both know exactly where you stand, Thomas, so it's good for both sides. We have a question from Joyce. Good morning from Joyce. What about two people who live together, not married, and both names are on the title, and one of the homeowners dies? Could the family of the surviving homeowner force the sale of the house, and they're entitled to 50% of the home? Okay, so you said, I'll answer that one, Catherine. That's okay. So there's the word title in there. So I'm assuming from your question, that's one thing about not being able to ask a live question. You have to assume certain things. So I'm going to assume a title is a mobile home, and the title says or, husband or wife. And when one dies, it automatically belongs to the survivor, and the first to die's family would not be entitled to any part of that. It would 100% belong. And your question was, are they entitled to 50% of the home, meaning your spouse's children? The answer would be no, under those circumstances. If it's not a title but a deed, the words on the deed are very, very important. If there's just two names, husband and wife, and it's presumed to be wife, that's tenanced by the entirety on a deed. And so the spouse also has a right to that. If there's a premarital agreement and you each own the home separately, tenants in common, then you probably, the premarital agreement would address the living rights of the spouse and the deceased person's half. And Joyce, you might need a more lengthy conversation. Catherine and I would be glad to talk to you about that if you have further questions. Next question. Your example of marriage after home in name of one with no agreement. When the home is entitled in the living trust, does the non-owner surviving spouse have a life estate? Catherine, you want to do that? Do you want me to do that?
That's your bailiwick, Joe.
Well, first of all, you can't, if you're married without a premarital or postmarital agreement, you can't legally even do a deed to transfer the home into the trust. The spouse can join in on signing the deed, and there's language in that deed saying that she waived her spousal rights and basically understood what she was doing when she signed the deed into the trust. The point is, basically, you could have a trust that gives her a life estate or the right to live there for life, and then she agrees to sign the deed, but you have the right to change the trust. So she might have waived her rights to put the house in the trust, and you could not be mad at her one time and be mad and change the trust. So got to be very careful when you're doing all that. You say with no agreement, so I'm assuming there's no premarital agreement, but she would have to join in on signing the deed, waiving her spousal right on the deed itself. Some attorneys will do those deeds, and some like to be more cautious than that and insist upon a pre or postmarital agreement. All right, so Thomas, we took his question already, so I can move down here and go to find the question right after Thomas. Let's see, I'm having trouble scrolling down here. Oh, here we go. All right, a question from Nancy. I think I saw that during the program. Do you have to be married in Florida to divorce in Florida? And Catherine, you said no.
That's right.
Okay. And here's the question. I'm married and divorced twice. Oh, that's Thomas. Okay. Continue to move down here. Been married and divorced. It's still Thomas. Hold on. Do both parties have to agree that divorce is broken? And that was really one of your points that we didn't get to, Catherine. So go ahead and take that one.
That's an excellent question, because and the answer is no. And if one spouse says the marriage is irretrievably broken, and it seems rather harsh, but that's it. And are there times when one party files, the other party comes in, and we're trying to file an answer to the petition for dissolution of marriage, and we either have to admit or deny the allegations? So what happens if you have a spouse that says, I cannot admit that the marriage is irretrievably broken? Well, Florida statutes do allow for you to file a motion with the court and ask that there be a stay or delay of the proceedings in order to allow the parties to reconcile or see and go to marriage counseling, etc. But we all know, look, if one party says the marriage is over, I don't want to be married to you, we may have made children together, but that's it, I'm done. Even if you try to go to marriage counseling, it takes two to make a marriage work. So the answer is, the long and short of it is, one party says it's done and over, irreconcilable, that's it.
All right, so our next question from the chat room is a common law married couple from another state considered married in Florida? A great question.
Okay, and the answer is and I think we look at it here, does Florida recognize common law marriages from other states? And the answer is yes, due to the full faith and credit clause, and they have constitutional rights to be able to move from one state to the other. And Florida will and must recognize a common law marriage from another state, but it has to be established in the other state. You can't establish it here.
What's the answer to the question, Catherine, if there's a same-sex marriage in another state before Florida authorized same-sex marriages? Is that, and they moved to Florida later? Is that?
You have the full faith and credit. I mean, Florida, we have constitutional rights to be able to move from one state to the next. And there's other concepts, comity, COMITY, and other legal aspects of it. So yes.
Yeah, there was a while that I remember, and I used to do family law a long time ago. Before Catherine, I used to do a few family law cases and draft pre and post marital agreements. But I kind of remember something. I remember exactly what it was in Florida. If a same-sex couple got married, there was a question about whether they could get and move to Florida. Could they get divorced in Florida once they became a Florida resident? Remember that little? That was a problem area in the law for a while.
Well, you also have public policy reasons and how to address all that. But now we don't have to worry about that because we have our same-sex marriage here in the state of Florida.
And it says one of the things there's a question about that. Isn't same-sex, I think my chat room is bouncing around here. Isn't same-sex legal federally, so it shouldn't be an issue? I am same-sex. Well, it's not an issue now, basically, in Florida.
Right.
The question about the living trust. The home was in the living trust before the marriage. To discussion of changes before the trustor dies, does the surviving spouse have a lifetime estate? Well, yes, because even though the house is in the trust, you got spousal rights, and the spousal right is to be able to live in the home for life, or even sell the home and take half the proceeds. So it doesn't matter that the home was an asset before the marriage. Catherine, you could discuss about what the rights are if there's a divorce. But upon death, the spouse has a spousal right to live there or sell the home, even if it was in the deceased person's trust before marriage.
Right. So, and this is a complicated area in marital and family law when, let's just say, the husband owns the house and he buys it as a single man. Then he gets married. He does not put the wife on the title, and then they get a divorce. And the husband, so it will always remain the husband's non-marital asset. The question is, does the wife have any, is there a marital component to that asset? And then we get into the issue of, is there a mortgage? Because if there is a mortgage and you're spending your income to pay down the mortgage, the principal balance is going down. And if you're making repairs and improvements to the home using your marital monies, meaning your income, then the wife, the non-titled spouse, can have a marital component to the house. So what's the best thing to do if you own a house and you're getting married? Have a prenuptial agreement. Because otherwise it is just, it's a tortured procedure trying to figure out how much the marital component is on the non-marital asset, because then you also get into the issues of active versus passive appreciation of the home, and you have to hire appraisers and forensic accountants, and it's just a huge mess. Huge mess.
All right, here's a great question, Catherine, that ties into what generally we both do. And I create these type of trusts all the time for people. The question is inheritance trust. Can a spouse have a right to an inheritance trust in a divorce? And I'm assuming that a parent died, left one of the spouse's money, and they kept it separate and put it in an inheritance trust. I'm assuming that's all the facts of the question. It's a very short question. Can a spouse have a right in the divorce against an inheritance trust?
Well, if you've got marital and you have non-marital assets, it's not unusual that people get inheritances of any form during the course of a marriage. If that asset is kept aside and not commingled in any form, then that can be set aside as that one spouse's non-marital asset. Now, here's the thing. What if you have an inheritance and then you start to dip into that inheritance to pay bills, to pay your credit card, to pay your insurances, to go on vacations, to do whatever? If you start chipping away at that non-marital asset with marital expenses, then there can be exposure. And then once again, it becomes a big mess. And you need to have your forensic accountants and the attorney fees start going through the roof. So how do you avoid this? If you're married and you're going to get an inheritance of any value that you're concerned, you want to make sure it stays on your side of the ledger, enter into a postnuptial agreement. And then so if the others, look, if you're getting, let's say mom dies, you're going to get $50,000. You tell your spouse, my mom died, I'm going to get $50,000. Some spouses will go, honey, that's yours. I don't want any part of it. Well, if that's the case, do a simple little postnup. So he's agreeing in writing that $50,000, whether you spend it for marital or non-marital purposes, whatever it is, at the end of the day, that remains yours. Other spouses will say, oh, you're getting that money from mom. Let's take that money. Let's pay down the mortgage. Let's use it for marital purposes. And they basically, your spouse wants to, tap into your non-marital inheritance. That can be a problem. So having that agreement, nice simple postnup, so that everybody knows what that money is supposed to be for and how it's to be categorized, either marital or non-marital.
All right, Catherine, believe it or not, we're down to our last question in the chat room, and we still have a little bit more time. So if you, the listening audience, has a question and you'd like to send it in the chat room, send it to us now, and we'll take this one question. And then if you have if you'd rather do a live question, raise your hand and we'll find you. And the last question right now in the chat room is, and this is a good question, Catherine, and we've talked about this before, and it seems to be a problem area in my mind. How is a common law marriage legally established in another state?
It all depends on the state, because some states I remember one time I'm trying to determine whether there was a common law marriage or not, which common law marriage basically means there's no documents, there's no license, there's no certificate. But some states, there's some sort of a certificate of common law marriage that can be filed with the clerk of the court. So it all depends on the state. Other states, you look at the common law approach to it of, did you live in the same home together? Did you basically hold yourself out as husband and wife? Do you share? Do you have a joint bank account? Did you make children together? Did you basically, are there all the indicia of being married, except for you didn't go down to the courthouse and actually get married? So you'd have to look to each state's particular rules about common law marriage, and it can be sticky. It can be sticky and very prickly. That's a legal term.
So even if a person, it seems like they think they're commonly law married, it becomes an issue, they can also get remarried. I mean,
Sure.
all right, so let's see. All right, so let's go back to your list. Okay, we have Robert. Unmute yourself, Robert, and go ahead and ask your question. Yeah, unmute yourself, Robert. All right, Robert can't hear you. It's a little unmute bottom. Hopefully.
Hello, I did it.
All right, there you go.
The issue's already been addressed about shared liability for a married couple. What happens when you have a joint ownership of a home with a couple that are not married? How do you keep the liability separate?
Is it the homestead of both of you?
Yes.
Well, a homestead is a protected asset in Florida. So you're talking about one of you go out and have a car accident and you get sued. Well, your homestead is a protected asset. You both own the property, so you both have a homestead protection, so they can't sue one of you and have any interest in the homestead because it's a jointly held property where both of you have declared it as your homestead. All right, you keep on muting yourself, Robert. Oh, there you go.
Would the other assets be attachable, whatever savings or investments they have?
It depends on how well, they're not titled husband and wife. So yeah, they could be attachable.
And let me mention one thing. So in the state of Florida, our homesteads are exempt. That's why we have, sports figures and actors and actresses moving here because they want to avail themselves of our very broad homestead exemption. Also, your retirement is going to be exempt from creditors and your annuities and your life insurance. But when it comes to larger bank accounts or investments, any collectibles, those can be not exempt. And what does not exempt mean? Available for the creditors to reach out and grab if there's a money judgment.
And that brings a good point for me to tell. I usually tell people that it's not good to have multiple names on a car title. So the reason is, my advice generally to clients is to put the name of the car in one person, the primary driver. If you're married and you have two cars, you put each one in the primary driver's name. And the reason for that is the primary driver is driving and has an accident, they can only sue the primary driver and they cannot get to the assets held jointly between husband and wife. So most of you, I would guess, unless you're a surgeon or something, most of you are most worried about lawsuits from car accidents. And one of the big tips about car accident protection of your own assets is to only have a car in one name, the name of the primary driver, particularly if you're married. And that goes back to one of the questions about you liable for a child's liabilities, Catherine, earlier. If they're under 18, well, you're liable for, they're in college and they're 21 and they're driving your car and you own it. They always sue the owners of a car.
Absolutely.
So asset protection is very, very important. Another question popped up in the chat room. And if you, we have about 10 more minutes. If you want to send more questions to the chat room, that's great. It says, during the divorce process, can the mother of kids prevent the father from seeing the kids unsupervised?
Can she prohibit the
spouse from seeing the kids unsupervised?
It's all about the best interest of the children. And if for some reason there's evidence and proof to show that the children would be in harm's way, it'd be a detriment, for the children to spend time with the other parent and they're not being supervision, then you can bring that to the attention of the court. There's different parenting plans that can be established on a temporary basis. One of them is just the regular parenting plan that most of the cases fit into. Otherwise, you can look to what's known as safety-focused parenting plans, where the visitation, or shall I say time sharing, is restricted to either being supervised or at a supervision center. The question is, if the time sharing is going to be supervised, who's going to supervise? You can actually have it where the other parent supervises, or maybe a family member, or maybe a friend, or maybe you have to find a third party that you have to pay. But it's all about the best interests of the children. The courts do want to promote regular, continual, predictable time sharing between the children and the other parent, unless there's harm or detriment that can be shown.
All right, next question in the chat room is, after divorce, do you have to allow the ex-spouse's family have visitation with your children if there's no legal agreement that says you have to?
The only people who are entitled to time sharing are the parents. All right, so mom's entitled, dad's entitled, you have a parenting plan. The question becomes, what about when the kids are with you? Can you bring them over to grandma or grandpa's house, or the aunt or the uncle? Once again, all about detriment or harm to the children. If the children are going to be placed in any kind of situation where there can be harm or something that's going to be not healthy for them, that needs to be brought to the attention of the court. The other thing is, however, when the children are with the dad, if there's no harm or detriment, the other parent doesn't have this ultimate right to micromanage what the other spouse is doing. All right. So it's basically, when the kids are with me, I'm going to do what I want to do. And we're either going to stay at home, or we're going to go out to the park, or we're going to go to the museum, whatever it is. But it's all about just best interest of the child. If there are any issues that you can't agree upon with the spouse, you bring it to the attention of the judge, and then he or she will make the decision for you and your children.
So I guess the second part of the question was, is your spouse allowed to give their visitation to his family? Are they to his family members? So, if the spouse comes to pick up the children, he can do what he wants to do with them, as long as it's in the safety of the children. But could he authorize a family member? I guess the question is, can you authorize a family member to come pick up the children, and then that visitation just is enjoyed by the person who picks them up, as opposed to the spouse joining in to pick them up?
Once again, it's all in the best interest of the children. Here in the state of Florida, we have in our parenting plans, it's not so elegant to call it this, but it's right of first refusal, which means if the child or children are not going to be with the other parent, or when they're with the other parent, if they need to hand the kids off to a family member or to some child care provider for X amount of time, they need to ask the other parent first whether they want to have time with the children. So let's just say it's 6 hours, okay? If you're going to have to hire a babysitter or turn the kids over to mom, grandma or grandpa, the right of first refusal period would be 6 hours. Then you need to ask the other parent, hey, I'm going to a Bucks game. I'm going to be gone for 6 hours. Do you want me to drop off the kids, or should I bring them over to my mom or dad's? So you can have short times for right of first refusal, or longer periods of time. But you have a right to know where your kids are, okay? I mean, because what if something goes wrong? What if the kids hurt themselves? What if something else happens to the other parent? Just keeping that dialogue. And here's one other thing for parents out there. This is a relatively new thing. There are communication apps. All of us have a cell phone now, right? And there's apps so you put on your phone, as opposed to text message or emails or calling or whatever it is. These communication apps, there's two of them. There's only two that I know of. One's called Talking Parents. The other one is Our Family Wizard. There are free versions of both, and there's versions that you pay for. But these communication apps mean that's how the parents just talk to each other. They don't use any other modes. And the reason why these communication apps can be good is that if there's some problems with the case and these issues need to be brought up before the court, they're easily admissible as evidence to the judge. So the judge and all the lawyers can see all the dialogue going back and forth between the parents and whether they're being respectable or not. So it's amazing.
All right.
Even when they are on Talking Parents, I say, don't say that, and they still do.
All right, we're gonna go to Joyce, who's raised her hand. Joyce, I don't see your picture, but you can unmute yourself and let me see if we can hear you. Joyce, are you there? All right, Joyce was raising her hand. So let's go. Can the grandparents have legal visitation of their children?
Oh, that's a rough one here in the state of Florida, because the answer is the grandparents have no rights to time sharing with their children here in the state of Florida. Yep, you heard that from me. I did not create that law. The law is still on the book. So if you think you're a smart guy or girl and you say, but Catherine, I read the Florida statutes and it says that the grandparents have rights. Well, yes, that is true. But the case law has come through, which basically cuts off the grandparents right at their knees, even if, listen to this, you have kids, and then one of the parents dies. Now, wouldn't you think the courts would say, well, let's say the father dies. Wouldn't you think the courts would say, well, let's allow the grandparents to come in so the kid or kids can at least know the other side, the father and his family. And if the mom says, no, I'm not going to allow that, the grandparents have no standing. And I mean, talk about harsh. Because here in the state of Florida, the parents have constitutionally protected rights against third parties unless there's abuse, abandonment, or neglect. I get grandparents calling me. I can't see my grandkids. I want to bring them toys. I want to take them out. I want them to understand my side of the family. I want them to join in family outings. Can you file something on my behalf? And I say, there's nothing to be filed. Now, can we try in a softer way, like, could we even request that there's sort of a mediation, and I call it like an intervention session that says to these parents, come on, can't we have the grandparents have some interaction? And but nothing would be binding, not in the state of Florida. I didn't create.
So our IT Troy has unmuted Joyce. So Joyce, are you there? Joyce, we can't hear you. So, all right. So there's a couple more questions in the chat room. So we'll take these two, and then that'll be the end of the session today. And just to let you know, if you would like to contact Catherine about a family law issue, you can reach her at 1-800. I don't know where you're calling from, but she takes cases all over the state now because of the Zoom courtrooms. But 1-800-226-3529. Go directly to extension 112, is it, Catherine?
Yes, please.
Right.
And
So
here's the other thing. So, and since you all are Zooming, whether it's you or it's a family member, we can, if you call me, we can create the Zoom invite, and we can have a one-on-one consultation by Zoom, and we can do the shared documents. It's even better than a telephone call. So we have that capability, and we want to just remind you that that's an option.
Oh, go ahead and give your contact information again.
Sure. Okay. So write down my email address, which is my last name, HULT@ATTYPIP.com. That's HULT@ATTYPIP.com. And to let you know, because of COVID and all, I'm in the office, or I might be at home. Sometimes I might do a Zoom from my dining room. I forward my office number to my cell phone. So if you need me, I should be accessible. So you should be able to find me.
All right. And just to let you know, we're doing another Zoom seminar in 2 weeks on Friday at 10 o'clock. The subject will be concealed weapons, what you need to know about concealed weapon rights and so forth. Hunter Chamberlain will be co-hosting that with me. He does a lot of criminal law as well. We're talking about some traffic cases. We're talking about expungement of records. So you have an old record from a long time ago you'd like to have expunged. We'll talk about when you can do that and so forth. And Catherine, we're going to try to get through these 2 more questions with short answers because we're past our time limit.
Can we do this again, Joe?
Oh
This
yeah,
is
let's
fun.
do it. We'll set it on a regular schedule. It's been fun.
Okay.
And we've got several thank you notes, and I'd like to thank you for your thank you note.
Yeah, thank you.
They're all in the chat room, and there are several of those.
Okay.
Here's the one though. Are there resources regarding child custody for a spouse, who cannot afford an attorney?
I think the best thing to do is to look at the parenting plan. And if anybody needs one of those Florida Supreme Court approved parenting plans, they have instructions at the beginning, and they also list out the factors that the court considers. I think there's 18 factors. So that's a great place to start. If anybody, can't find it online, just send me an email and I'll shoot that out to you. No problem.
So the last question, if both couples are receiving pensions, can you have in a divorce decree that upon death of one spouse, the pension can only go to the surviving spouse and not to any of their spouses?
It all depends on the pension plan, but when you go through a divorce, the way you divide up the pensions is known as a quadro, QDRO, and the quadros are very specific. It also makes a difference whether you're still working or whether you're in retirement status, because if you're in retirement status, and if all the pension has accrued during the course of the marriage, that would be marital. But if you're still working, as of date of filing, any monies that would accrue after that would be non-marital. So there's different components, but the quadro, you can designate who does get those monies or not, and depending on whether it's marital or non-marital.
All right, so we have a message from it. It says, great Zoominar and great to see Catherine. They don't mention me in that, Catherine.
Joe.
And I thank you, and thanks Catherine and Joe. Awesome Zoom meeting. Thank you for a good another webinar. Keep it up. Thank you so much. For those that want to attend our next Zoom seminar, if you'll just email Troy, TROY @ATTYPIP.com. He will get you all set up and send you a link to the meeting. If you'd like to call our office, either myself or Catherine, we have a toll-free number, 1-800-226-3529. If you want Catherine, it's extension 112. If you'd like to get to me, extension 200. And we don't charge for first appointments or phone consults or Zoom meetings on individual Zoom meetings. There's no charge for that first setup there, and we could probably set a flat fee for whatever you need done fairly quickly. And so thank you so much. Thank you, Catherine.
Thank you. I want to say thank you and a special call out to all those moms out there who are so dedicated to their children and give all their heart and soul to their kids and to those dads and grandparents. Thank you so much for allowing us to be part of your day. And I really look forward to our next one.
All right, very good.
Hey, everybody, just 2 things right quick. If you have received an email from me for the last 6 seminars, you're already on the list. So no need to send me an email if you want to join the next one. You will automatically get the Zoom invitation. And also, I have 3 out of 6 of these already up on YouTube. So probably Monday or Tuesday, you'll get an email with all 6 links to watch these 6 Zoom presentations next week.
Yay.
And don't forget to listen to Ask an Attorney all about Florida law tomorrow morning at 8 o'clock on multiple stations, 570, 910, 860, 930, or several of them. If you're in Jacksonville, it's WBOB 600 on the dial. And Sunday morning right now, I'm doing 3 hours on 970 from 6 to 9 o'clock. Those are all live radio shows where we just attempt to help people and answer legal questions. And y'all have a great weekend. So long.
Thank you, Joe. Appreciate it.
Bye-bye.
Bye. Bye.